March 10th, 2026. Under the soaring Gothic arches of Westminster Abbey, the air did not simply feel cold, it felt electric. It felt like the specific, crackling atmospheric charge that precedes something irreversible. The kind of tension that fills a room, not because of what is being said, but because of what everyone in it already knows and is pretending not to know. The world watching from outside saw a fashion icon, Catherine, Princess of Wales, stepping from her royal vehicle in a striking navy ensemble that would generate 10,000 column inches before the day was out. A wide-brimmed, structured hat that commanded attention and deflected it at the same time in the way that only the finest royal dressing manages to do. The cameras loved it. The fashion press would spend the rest of the day analyzing every seam and silhouette. But behind the palace walls, behind the careful composure of the senior courtiers positioned along the receiving line, what the people who understood what this day actually meant were watching was something the cameras could not quite capture. They were watching the arrival of the new landlord. The man and the woman who, as of 8 o'clock that morning, held the keys to the monarchy's most secretive, most valuable, and most carefully protected private assets. And they were watching the expression on the face of the people who had just discovered, definitively and without any remaining avenue of appeal, that those keys would never belong to them. This is not simply the story of a Commonwealth Day service. It is the story of a dynastic coup that had been years in the preparation, executed with the precision of a legal instrument refined over decades by a woman who understood exactly what she was building and exactly who she was building it against. It is the story of a hidden document on vellum discovered in the small hours of the morning by a princess who had not slept in 36 hours. It is the story of a 22-year-old with a scholar's eye for documentary anomaly who found a shell company registered in Luxembourg 3 weeks before a queen breathed her last and understood immediately what it meant. It is the story of a letter sealed in red wax, delivered by private courier to a queen consort's private quarters, containing a sentence that has since passed into palace legend. And it is the story of a family that spent 2 years meticulously constructing a commercial empire on foundations they believed were solid and discovered on the morning of March 10th, 2026, that every single one of those foundations had been legally dissolved before the first brick was ever laid. At precisely 10:46 a.m., 4 minutes after Catherine's vehicle arrived at the Abbey's great north door, a moment occurred that every body language analyst in the country would spend the next 72 hours dissecting. Tradition at events of this significance calls for the senior royals to greet one another with the warm, practiced double kiss that communicates continuity and unity and the appearance of family harmony that the institution has always understood to be as important as any constitutional arrangement. Camilla leaned in, and Catherine's hat, that wide-brimmed, architecturally precise, breathtakingly well-chosen hat, acted as a literal physical barrier between them, a borderline made of felt and netting, a structured perimeter that required no explanation and offered none. One witness positioned near the great north door reported hearing a sharp intake of breath from the Queen's entourage, a sound quickly swallowed by the organ music and the murmur of the congregation settling into its pews. The princess did not flinch. She did not adjust her position or her expression or the angle of the hat. She simply occupied her space with the particular quality of composed, unhurried certainty that she had been developing for years and that had reached, since her return from illness, a kind of crystalline perfection. A high-ranking palace aide, speaking to reporters later under condition of anonymity, was direct about what had just been witnessed. The princess, the aide said, had been instructed to maintain a physical perimeter. The era of easy access to the inner circle was over. And the hat, chosen weeks in advance, approved at the highest levels, was the first visible announcement of that reality to the people who needed to understand it. But the hat was only the surface of the story. The real announcement had been made 97 minutes earlier at 9:45 a.m. in a communication that never reached the press and was not intended to. At that moment, The Metropolitan Police issued a special category protection order, a mechanism reserved in its most specific application for the sovereign's private land that officially transferred the security details for the Cedar estate and Northacre Hall from the General Royal Protection Pool directly to the Prince of Wales's private command. The implications of that transfer were immediate and total. Everything that had been accessible through the general pool was now accessible only through William. And everything that had been assumed to remain accessible on the basis of commercial interest, personal relationship, or the informal understandings that had governed certain arrangements for the past several years was now, as of 8 o'clock that morning, inaccessible. A senior lawyer for the Duchy of Cornwall, overheard in a corridor outside the Abbey's administrative offices, summarized the situation with the kind of precision that lawyers deploy when they want to be absolutely certain they have been understood. Access, the lawyer said, is a privilege, not a right. And as of this morning, that privilege has been revoked by the sovereign's direct mandate. To understand why those words landed with the force they did, and why the Parker Bowles family was sitting in those Abbey pews in a state that insiders would later describe as barely contained radioactive fury, you have to understand what had been built, what had been discovered, and what had been legally demolished in the 72 hours preceding the service. Because what happened on Commonwealth Day 2026 was not a spontaneous confrontation or a sudden decision. It was the final, visible, irreversible act of a process that had been running in parallel with the public life of the monarchy for months, hidden in archive rooms and digital servers and sealed correspondence, moving through the institution with the quiet, unstoppable momentum of water finding its level. Look closely at the earrings Catherine wore that morning. The historic Bahrain pearl drops gifted to Elizabeth II in 1947 as part of a presentation from the ruling family of Bahrain are not simply a beautiful and historically significant piece of jewelry. Within the specific emotional and symbolic language of the royal family, they have always carried a particular meaning that goes beyond their material value. They have been reserved by an understanding so long established it has the quality of formal tradition for occasions of succession and confirmation. Occasions when the chosen heir needed to communicate, without speaking, that the line had been drawn and the future had been decided. By wearing them on the morning of March 10th, 2026, Catherine was not making a fashion statement. She was making a declaration. The line of succession has been locked. The chosen heir has arrived. And he has brought the keys to the kingdom with him. The 945 protection order was the legal underpinning of everything the earrings were communicating symbolically. The Cedar estate, 6,000 acres of private land in the Chiltern Hills, containing hunting lodges, ancient woodland, and a network of outbuildings that had been maintained under royal ownership for over 2 centuries, was now under William's direct authority. Northacre Hall, the 17-room Georgian manor, that had served as a private retreat for 3 generations of the royal family, and whose grounds included a working farm, a private lake, and a collection of estate buildings that a certain kind of entrepreneurially minded individual had begun to imagine in quite different configurations, was similarly transferred. The commercial possibilities that had been attached to these properties in the minds and the business plans of certain interested parties were not simply deferred or complicated by this transfer. They were ended. A legal representative for Tom Parker Bowles attempted to block the security transition at the last minute. The attempt was made through a formal objection filed with the Metropolitan Police's Specialty Command, arguing that his client's commercial interests at Northacre Hall specifically, the preliminary development agreements that had been put in place in connection with a proposed hospitality venture required continued shared access to the estate's administrative facilities. The response from William's legal team arrived within the hour and was, by the accounts of everyone who heard it, comprehensively final. The lawyer's words moved through palace circles with the speed of a story that everyone recognizes as historically significant the moment they hear it. Access is a privilege, not a right. As of 8 o'clock this morning, that privilege has been revoked by the sovereign's direct mandate. Tom Parker Bowles had, by the autumn of 2025, reached a level of confidence about his commercial ambitions for the royal estates that those around him found either inspiring or alarming depending on their perspective. He had registered a holding company in Luxembourg under the name Stag Crown Hospitality. The business plan was detailed, professionally prepared, and startling in its specificity. The Queen's private hunting lodges on the Cedar estate would be converted into elite boutique retreats, a maximum of 8 guests at any one time, a waiting list that would take years to join, a price point that would make the most expensive hotels in London look democratic. The Northacre Hall farm buildings would become the production base for a range of artisanal food products trading under the brand Royal Wild, cedar-aged cheeses, honey harvested from the estate's ancient hives, preserves made from fruit grown in the walled kitchen garden. High-end retailers in London and Dubai had already been approached. Preliminary expressions of interest had been received. The figures being discussed were, by any measure, significant. What Tom Parker Bowles had apparently not known, what nobody outside the innermost circle of the late Queen's most trusted legal advisors had known, was that Elizabeth II had spent the final years of her reign constructing a legal architecture around these properties with the specific and deliberate purpose of ensuring that exactly this kind of plan could never be realized. The instrument at the heart of that architecture was what palace legal staff had come to refer to, in the shorthand of people who spend their days navigating extraordinarily complex constitutional documents, as the anticipatory obstruction clause. Its formal designation was considerably more technical. Its practical effect was not. The mechanism worked in 3 stages. In the first, the properties were moved into a covenant trust beyond the reach of ordinary property law. In the second, the trust activated its most significant protections only when the heir was formally recognized as the institutional lead of the relevant estates, which occurred on the morning of March 10th with the execution of the protection order transfer. The third stage was the element that made the clause devastating. It contained an explicit bar on any individual who had entered the royal family through marriage after the year 2010 from holding any administrative or beneficial interest in the covered properties. The year was not accidental. Camilla had married Charles in 2005. She was inside the boundary. Every member of her family who had entered the extended royal circle through her marriage was outside it. The clause did not name anyone. It did not need to. Elizabeth II had constructed a legal cage around her grandson's inheritance and built it, with the care of someone who understood exactly what she was protecting against from the inside out. Inside Westminster Abbey, as the congregation rose for the opening hymn, Prince William stood with a quality of stillness that those who knew him well recognized as something different from ordinary composure. He was not simply present at a service. He was surveying a domain that had, as of that morning, formally become his to govern, to protect, and to define the future of. Princess Anne, seated just behind the king in the arrangement that protocol dictated, was seen by several observers to turn briefly toward William with an expression that contained, in the reading of those present, the particular satisfaction of someone who has completed a very difficult job correctly. For 72 hours before the Commonwealth Day service, while the world's attention was focused on the approaching ceremony and the fashion choices being made in preparation for it, Princess Anne had not slept. She had been in the Oak Room at Windsor Castle, a chamber that does not appear in any official guide to the castle's public spaces, that is not on any tour, that most people who work inside the building have never entered, surrounded by centuries-old leather folios, dust-covered registries, and the particular quality of silence that exists only in rooms where very old documents have been kept for a very long time. She had been conducting what those who knew what she was doing called, with a precision that understated its actual significance, a forensic heritage audit. Anne had always been the family member most willing to go into the archive. Not because she was the most legally sophisticated, though her understanding of royal constitutional law was formidable, but because she was the member of the family most genuinely motivated by the desire to understand what had actually happened, rather than what had been said to have happened. She trusted documents in a way she did not always trust people. Documents did not have agendas. Documents did not soften inconvenient information to preserve relationships. They simply recorded what had occurred. And Anne had learned, over decades spent navigating the gap between the institution's official narrative and its lived reality, to trust that record above almost everything else. At approximately 3 o'clock in the morning on March 8th, she found what she had been looking for. Or rather, she found something she had not specifically been looking for, but recognized immediately, with the instinct of someone who has spent decades reading royal documents, as significant. It was a single sheet of vellum, filed in a leather folio dated 2021, labeled in the indexing system of the archive, with the designation Appendix R3. The document was signed by Elizabeth II. Its contents classified the Cedar estate not as a family asset subject to the ordinary rules of royal inheritance, not as a property that could be managed, administered, or commercially developed by any member of the extended royal family who held an appropriate interest, but as a sovereign inviolate holding. The language was technical in its construction, but absolute in its implications. The Cedar estate belonged to the crown. It would pass to the heir, and no mechanism existed within the trust structure that would allow any party without a direct bloodline claim to exercise any form of control over it. Anne did not simply file the document and report its existence. She weaponized it. As the head of the Crown Trust Authority, a role whose formal title understated its practical reach in ways that those who had underestimated it had always come to regret, she had the authority to act on the document's provisions immediately and unilaterally. At 9 o'clock on the morning of March 9th, she signed a lockout order. The order was both digital and physical in its application. It immediately revoked the security clearances of every legal consultant and financial advisor with any connection to Camilla's household or to Tom Parker Bowles's commercial network. Access to the relevant sections of the royal archives, to the administrative systems of the Cedar estate and Northacre Hall, and to the legal documentation held in the Chiltern Hills vault was terminated. A senior clerk at the Royal Archives, who witnessed the moment when the consequences of the order became apparent, described what happened when Camilla's lead solicitor arrived at the vault and attempted to enter as he had done on previous occasions. The system turned red, the clerk recalled. When the solicitor called Princess Anne's office directly, her instruction was relayed without elaboration. No bloodline, no entry, no exceptions. The lockout would have been dramatic enough on its own, but what had triggered it went beyond the discovery of Appendix R3. Within the Queen's private correspondence, letters, and communications that had been held in sealed storage since Elizabeth's passing, and that Anne had been authorized to review as part of the heritage audit, she found something that transformed the situation from a legal dispute into something considerably more serious. There were emails, not correspondence between family members. Correspondence between Camilla's legal liaison and luxury hospitality partners in the United Arab Emirates. The subject line of the thread was 3 words: the Northacre Project. The content of the emails detailed, with a specificity that left no room for innocent interpretation, a plan to convert historic Northacre Hall into a 5-star boutique hotel and spa. The proposal included a celebrity chef residency for Tom Parker Bowles himself, a wellness program built around the estate's natural setting, and a spa menu, the mock-ups of which were attached to one of the emails, featuring treatments described as Windsor wild honey therapies and royal heritage skin restoration rituals. The honey in question was to be sourced from the hives that had been maintained on the estate for over a century. The heritage in question was not theirs to sell. Anne's reaction, as described by the courtier who was present when she finished reading the correspondence, was not loud. It was the kind of quiet that is more frightening than any raised voice, because it suggests that the person producing it has already moved past the stage of emotion and into the stage of decision. She requested a private briefing with King Charles that same day. Her words to him, as they were later reported through palace channels, were unambiguous. Their mother had left them a legacy to guard, not a portfolio to liquidate. If Charles would not stop what was happening, Anne would. The king, by all accounts, did not argue. The document discovery in the Oak Room was Anne's contribution to what would become the legal architecture of March 10th. But the most operationally significant piece of evidence, the element that transformed a defensible institutional dispute into an irrefutable case of intellectual property theft against the crown, was found not by a 74-year-old princess with decades of experience navigating royal legal complexity, but by a 22-year-old student who had been working night shifts alongside her aunt for weeks and who possessed, in addition to her historical education and her personal loyalty to the institution, a talent for documentary forensics that nobody outside the family had suspected she had developed. Lady Louise Windsor had spent months quietly building expertise in the kind of cross-referencing work that the digital age had made both more powerful and more revealing than any previous era of archival research. The ability to map physical documents against digital registries, to trace connections between named individuals and corporate entities across multiple jurisdictions, to identify the metadata signatures that link a document created in one location to a server operated in another. These were skills that had emerged from her academic work, but that she had been applying. With Anne's encouragement and William's knowledge, to the specific question of what Tom Parker Bowles had been doing with the royal estate assets he had been given informal access to during the years when the family's internal boundaries had been less carefully maintained than they were about to become. At approximately 2 o'clock in the morning on March 8th, scanning through international trademark filings in the Luxembourg Business Registry as part of a systematic cross-referencing exercise, she found it. A shell company registered under the name Hill and Crown Limited. The registration date was what stopped her. 3 weeks before the late Queen's passing in September 2022, the company had been incorporated, its filing documents prepared and submitted. Its executive director formally listed Tom Parker Bowles at a moment when Elizabeth II was still alive, still the reigning monarch, still the legal owner of every asset the company's name appeared to reference. The senior archivist working alongside her at that hour recalled her response. She did not shout. She did not immediately reach for her phone. She pointed to the screen, turned to Princess Anne, and said quietly, "He was already selling the furniture before the house was empty." What followed was the 4-step cross-referencing protocol that transformed a suspicious discovery into an irrefutable legal case. Louise mapped every private asset of Elizabeth II against the trademark requests filed by Hill and Crown Limited in the months surrounding the Queen's death. The exercise produced matches specific, historically documented matches. The most significant was a centuries-old heraldic crest from the Cedar Estate Hunting Lodge, a design element that had never been reproduced publicly, existing only in documents within the royal archives. That crest had been airbrushed onto luxury wine labels and honey jar packaging in the Royal Wild prototype materials. Its use had been authorized by Tom Parker Bowles. Its use had never been authorized by the sovereign. The 4th step of the protocol was the one that closed the legal trap entirely. By analyzing the metadata of the design files containing the unauthorized crest, Louise was able to identify the digital server on which those files had been created and stored. That server was operated by Camilla's communications team. The crest had not been independently obtained. It had been accessed through the administrative systems of the royal household itself, copied and incorporated into commercial product designs without any form of sovereign permission. This was not a business mistake or an error of judgment about the boundaries of commercial appropriateness. It was a coordinated attempt at intellectual property theft against the crown. Louise presented the evidence to Princess Anne. Anne called William. William's response was a single sentence delivered with the coldness that very controlled anger produces in people who have learned to contain it. Send the evidence to the Lord Chancellor. He wanted the trademark denied by dawn. As Tom Parker Bowles arrived at Westminster Abbey on the morning of March 10th, a formal notice of infringement was waiting for him. He had been outmaneuvered by a 22-year-old who had chosen, at every decision point in the process, loyalty over profit. To understand the full scale of what collapsed on Commonwealth Day, you have to trace the arc of what had been built. Because Tom Parker Bowles had not been careless or impulsive in his ambitions. He had been methodical, patient, and until the moment the archive yielded its secrets, genuinely strategic. The timeline of the Parker Bowles commercial project is a study in the specific kind of overconfidence that comes from believing that personal proximity to power is a permanent substitute for the legal authority that actually governs it. In November 2025, Tom was at the peak of his certainty. The Royal Wild brand was approaching commercial viability Cedar-aged cheeses from the Cedar estate's private groves. Honey from hives traceable back a century, preserves presented in packaging referencing the estate's heraldic history. Preliminary orders from high-end retailers in London and Dubai represented several million pounds of committed revenue. The Northacre Hall boutique hotel had moved from concept to detailed architectural drawings. Stag Crown Hospitality had attracted Gulf-based private equity interest. Tom believed he had the king's silent backing. He had fundamentally and fatally underestimated the vault of silence Elizabeth II had built around her grandson's future. By January 2026, the legal ground was visibly shifting. Camilla summoned elite constitutional lawyers to a closed-door summit at Highgrove, intending to contest William's exclusive inheritance of the Chiltern Hills properties. One witness recalled her words to the assembled team. These estates had been maintained by the public profile of this family for 80 years, she said. It was a matter of equity that the current Queen's family should have a seat at the table. What she did not yet know, what nobody outside Anne's circle of trust knew, was that the table had already been removed. On February 3rd, 2026, the legal trap detonated. Prince William officially received the keys to the 6 private estates in a ceremony conducted in the Green Drawing Room at Windsor Castle. The anticipatory obstruction clause was read aloud by the Lord Chancellor's representative. The room was small. The implications were enormous. A senior footman who was present at the reading, and who has since described the moment in private conversation, recalled Camilla's response to hearing the clause that barred post 2010 entrance by marriage from any administrative or beneficial interest in the properties. She read the document twice, he said. She did not raise her voice. She did not challenge anyone in the room. She turned to her son, who was standing beside her, and said, "She saw us coming years ago." The footman said the room was completely silent for nearly a minute after she spoke. The commercial consequences cascaded within days, 48 hours after the lockout order was finalized. The major international publishing house that had been contracted to publish Tom's high-profile cookbook, a project built substantially around the Royal Wild brand and its association with the Cedar estate's culinary heritage, officially canceled the agreement. The reason given was legal exposure. Lady Louise's digital audit had been summarized in a communication to the publisher's legal team, and the unauthorized use of royal crests and Cedar estate imagery in the prototype materials made the project uninsurable against the lawsuit from the Duchy of Cornwall that any publication would inevitably attract. Tom was left with hundreds of thousands of pounds in sunk costs, a brand whose visual identity had been legally demolished, and a business plan that had been structurally perfect in every respect except the foundational one. Every artisanal cheese, every boutique hotel, architectural rendering, every luxury honey jar with its airbrushed heraldic crest had become worthless overnight, not through market failure or commercial miscalculation, through the patient, precise, long-planned legal architecture of a dead woman's handwriting. The moment that the public saw and misread was the embrace. As the national anthem faded into the ancient stone of Westminster Abbey and the congregation prepared to be seated, King Charles turned to his eldest son and pulled him into a broad, warm, publicly visible hug. The cameras captured it. The reaction was immediate and almost universally mischaracterized as a touching moment of fatherly pride. To the legal teams watching from the sidelines of the ceremony, it was something considerably more specific. It was a declaration. By embracing William so publicly, so warmly, and with such evident deliberateness at this precise moment, on this precise day, Charles was communicating to everyone who needed to understand it that he had made his choice. The bloodline had been chosen over the commercial ambition. The institution had been chosen over the family politics. The future had been chosen over the convenience of the present. What the public embrace concealed was the private ultimatum that had preceded it by 48 hours. On the evening of March 8th, a red wax-sealed letter was delivered by private courier to Camilla's quarters at Clarence House. The letter was signed by the king. Its central sentence passed through palace circles in the days that followed with the quality of something people felt needed to be remembered, precisely read as follows. Any action taken to undermine the final will and testament of Elizabeth II would be treated not merely as a family dispute, but as an act of betrayal against the crown's memory. It was not a warning in the ordinary sense. It was a legal kill switch, dressed in the language of family correspondence. Every avenue of challenge had been closed. The mechanism Charles used operated in 3 stages. The first began on March 7th when Princess Anne delivered the forensic financial dossier to the king's study. It detailed the irregularities uncovered by Lady Louise regarding the Hill and Crown Limited Shell Company, the unauthorized trademark applications, the misappropriated crest designs, and the evidence linking Camilla's communications infrastructure to the product development that had incorporated them. Most devastatingly, it documented that Tom Parker Bowles had been pitching the Cedar estate as collateral to foreign investors without any royal authorization. The king was deeply saddened by what he read. He was also, in equal measure, furious. The second stage came on March 9th, when the king's private secretary filed a directive to the Lord Chancellor's office invoking sovereign immunity over the Oak Ridge estate and the Cedar estate. This move, unprecedented in its application in the current era, effectively placed both properties beyond the reach of any legal challenge that sought to reclassify their status or argue for shared management on the basis of their historical association with the broader royal family. Camilla's lawyers had been preparing precisely that argument, working on the theory that properties maintained under the public security umbrella of the monarchy retained a form of communal interest that the queen consort had standing to represent. Sovereign immunity rendered that argument legally irrelevant. The estates were inviolate sovereign holdings, accessible only through the direct heir. The argument had nowhere left to go. The third stage was the most politically sophisticated. To avoid a public scandal involving formal criminal charges against Tom Parker Bowles, Charles offered Camilla a deal. The Luxembourg dossier would be kept from the press. The trademark infringement proceedings would proceed quietly through administrative channels rather than as a criminal matter. In exchange, Camilla would sign a mandatory support pledge, committing her to publicly endorse William's environmental and educational vision for the estates, appear at the launch of the Greenheath Royal Future Trust, and provide no opposition, public or private, to the charitable codification of the properties. She signed. She had no other viable option. When Charles pulled William into that warm, public embrace at the Abbey, the deal was already done. By 5 o'clock on the afternoon of Commonwealth Day 2026, while the royal motorcades were disappearing into the London fog and the last photographs from the Abbey were still circulating across every platform on which they could be shared, Prince William and Catherine, Princess of Wales, signed the inaugural charter of the Greenheath Royal Future Trust in a private ceremony at Windsor Castle, attended by a small group of legal witnesses and no press. The trust had been structured around a discovery that even those closest to William had not been informed of until the previous week. Within the sealed financial records of Elizabeth II's private estate records that had been held in the Vault of Silence, the informal name given by archive staff to the most restricted section of the Cedar estate's own administrative building, a section whose existence was not documented in any public record of the estate. Anne's audit had identified a fund, a private financial reserve built quietly over decades from the revenues of the estate's working operations and invested through mechanisms that left no public trace, that had accumulated to a value of £37 million. Camilla had not known it existed. Tom Parker Bowles had not known it existed. The financial advisors who had been planning the commercial development of the estates had not known it existed. Elizabeth II had known it existed, had maintained it, had grown it, and had left it through the mechanism of the Covenant Trust and the Sovereign Immunity Directive, entirely and exclusively in the control of her grandson. William used it to build something that made commercial exploitation of the estates not merely legally prohibited, but practically impossible. Every acre of the Greenheath estate, the Cedar estate, and Northacre Hall was permanently dedicated, through the terms of the trust charter, to environmental education programs and child rehabilitation initiatives. The working farm at Northacre would become a residential educational facility for children from disadvantaged backgrounds, offering practical agricultural education alongside academic support. The ancient woodland of the Cedar estate would be managed as a protected research environment for environmental science programs, partnering with British universities. The hunting lodges that Tom had planned to convert into boutique retreats would become residential spaces for the educational programs, housing participants during their time on the estate. The legal genius of the arrangement was its irreversibility. By codifying the land as a protected nonprofit sanctuary, William had made it impossible for any future challenge to restore its commercial potential. You cannot build a 5-star spa on land that has been legally classified as a protected wildlife classroom. You cannot run a boutique hotel on a site whose charitable designation makes any commercial activity within it a breach of trust law. The Parker Bowles commercial footprint had been erased, not by confrontation or by punishment, but by transformation. The land had been given a purpose that made the previous plans for it not merely unwanted, but legally void. By the evening of March 10th, those inside the institution who had been following the legal developments closely enough to understand their full implications had begun to map the most likely paths forward for the parties who had found themselves on the losing side of the day's events. The analysis produced 3 distinct scenarios, each with its own probability and its own implications for the longer-term dynamics of the royal family. The first scenario, carrying roughly a 15% probability, was the public challenge. Camilla could contest the anticipatory obstruction clause in the High Court, arguing its post-2010 marriage bar represented a prejudicial exclusion. The argument was not without technical merit, but the cost would be devastating. Any public trial would force disclosure of the Luxembourg dossier, the trademark applications, the misappropriated crest designs, the unauthorized foreign investor pitches. Everything kept from the press under the terms of the deal Charles had offered would become public record. The legal argument might be viable. The reputational cost of making it was not survivable. The second scenario, carrying approximately a 25% probability, was the managed retreat. Tom dissolves the Luxembourg shell companies, withdraws from all royal heritage branding, and negotiates a minor, non-hereditary consultancy role that provides financial stability while keeping him politically silent. Princess Anne's control of the Crown Trust Authority made even this limited accommodation unlikely. Any arrangement directing royal funding toward Parker Bowles' interests required her administrative approval. That approval was not forthcoming. The third scenario, already 60% of the way to being realized on the evening of March 10th, was what analysts had begun calling the Great Silence. Not a negotiated settlement, but a simple cessation. Commercial projects abandoned, shell companies dissolved without announcement, legal challenges quietly dropped. The Great Silence required no further action from William's side. The trust charter had been signed. The land had been permanently dedicated. The legal fortress was complete. All that remained was to wait for the people on the other side of it to accept what the documents had already decided. At 8 o'clock in the evening, on March 10th, 2026, as the city settled into the particular kind of post-event quiet that follows a day of high ceremony, Prince William drove himself not in an official vehicle, not with the standard security detail, but in the kind of unremarkable car that allows a person to move through London without generating the attention that accompanies the appearance of the institution to the Cedar estate. He entered through the service gate on the estate's western perimeter. He walked through the administrative building to the section that the archive staff had been calling the Vault of Silence for longer than any of them could remember, and he went in alone. The vault was a long, low-ceilinged room lined on both sides with oak storage chests of varying sizes, each one numbered in the sequence that Anne's audit had established and cataloged over the previous 72 hours. 186 chests had been opened, reviewed, and documented during the audit. Their contents had been mapped, indexed, and incorporated into the forensic report that Anne had delivered to the king. William walked past all of them. He walked to the end of the room and stopped in front of a single unmarked trunk positioned against the far wall. It had no number on its exterior. It had not appeared in any indexing system. The audit team had found it, noted its existence, and on Anne's specific instruction, left it untouched. He opened it alone. Inside, on top of whatever else the trunk contained, was an envelope. The envelope was sealed with the personal seal of Elizabeth II. On the front, in the handwriting that a generation of palace staff had spent decades learning to recognize, was a single word: William. The letter inside was dated September 8th, 2022, the day she died. He read it standing in the vault with the lights of the estate's exterior grounds visible through the high, narrow windows and the sound of the wind moving through the cedar trees that gave the estate its name. He has not yet disclosed its full contents. What has been described by a source whose proximity to the situation gives their account a weight that cannot be easily dismissed is that the letter contained information about a third party, a financier, someone who had been involved from across the Atlantic in providing the initial capital structure for the Luxembourg entities that had formed the basis of the Parker Bowles commercial network. Someone whose name William recognized, someone who had been, in the years since Elizabeth's death, presenting themselves in royal circles as a friend to the family while simultaneously providing financial infrastructure to the commercial project that had been designed to exploit the assets of his inheritance. Elizabeth had known. She had known in those final weeks and days when the world was watching her decline with the public grief of people who understood they were witnessing the end of an era, and she had chosen to tell him in this way. Not through the legal documents, which dealt with what could be prevented, but through a private letter placed in an unmarked trunk at the end of a numbered sequence, accessible only to the person she had spent the final years of her reign building a legal fortress to protect. She had left him not just the land and not just the legal architecture, she had left him the name. What William does with that name when he chooses to act on what the letter contains, how he chooses to surface the information, and what consequences follow for the person it names is the question that the events of Commonwealth Day 2026 have left unresolved. The vault has been opened, the letter has been read. The great silence that has descended over the Parker Bowles commercial empire is real and it is total. But the story that Elizabeth II started writing on September 8th, 2022, in the last hours of the longest reign in British history, has not yet reached its final page. Somewhere between London and California, a name is waiting. And the man who now holds every key to every estate his grandmother spent a lifetime protecting knows exactly whose name it is.